still fashionably late, huh?
Yeah, well, nobody,
Long
nobody,
Lake couldn't have been too
nobody
much
ought
fun.
to be out on the road right now, I can tell you that.
So,
Okay, I'm going to call this meeting to order. This is the Grand Traverse County Board of Commissioners special budget meeting. Today is Friday, February 21st. It's 3 o'clock. And if we do the Pledge of Allegiance, please. Pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. We have roll call, please.
Commissioner Wheelock?
Yes.
Thomas?
Yep.
Rennie?
here,
Maxwell and Lathrop are excused. Inman?
here.
Chairman Lemkool?
Here. Okay, thank you. At this time, we'll have public comment. Is there anybody from the public that would like to make a comment? If not, we'll dispense from the reading of the rules. In that case, then we'll go on to probate court. Judge, thank you for being here. And would you introduce some of your staff that's here, please?
We'll start with the probate court staff. That's a simple. My name is Judge Melanie Stanton. I am the judge over the probate court and the family division. In probate court, we have our new probate register, who is Amanda Flowers. Amanda would like to stand up. She was appointed as the new probate register in September, and she's doing a fabulous job, making a lot of changes. With respect to the family court, if Ms. Conklin will stand up, I have Diane Conklin, who is a court administrator, and she came with me when I started my tenure as judge, and she is one of the most organized people that I ever worked with in my life, and I don't know what we would do without her. She's invaluable, and we all shake our heads over there. And then next to her, we have Miss Mandy Lear, and she's been in charge of the collections for the family court. In the front row, we have Miss Linda Fawcett, who I'm sure a lot of you are familiar with. She's been around for many, many years, and she runs our wonderful volunteer services that without them, I don't know what we would do, because they take up all the slack when no one else wants to do. You said the kids and elderly people and people with mental illness. And then we have Mrs. Donaldson. Mrs. Donaldson, Barbara Donaldson, she is the probation supervisor. And she's been with the courts how many years?
Wow.
Yep, 30-ish. And then we have Miss Heather Prevost. And Miss Heather Prevost, I think came just before I did. Is that correct, Heather? And she is the truancy, the head of the truancy division. And she does all the preventative. With that, I do believe that we do have Miss Amanda Flowers, who would, and then we have Miss Kirsten Kylitz in the back. And she's not officially with our side, she's with the other side, but she's with us. Right? I mean, organizationally. And with that, I'll Miss Flowers to go ahead with her presentation with respect to the probate court.
Good, thank you.
Thanks.
Good afternoon. I'm Amanda Flowers. As Judge was saying, you all have a handout. It says probate court on the top. I'll start with overview of services provided and our dedicated staffing. Probate court has 3 full-time employees and 1 part-time employee who works 24 hours per week. The full-time employees are myself, the probate register. We have a deputy probate register and an office specialist. And our office clerk is the part-time employee. She works 24 hours per week. Our customers. We serve the indigent, the elderly, the mentally ill, minors in need of guardians or conservators, the homeless, people with estate plans, people without estate plans, developmentally disabled adults, and incapacitated individuals. How many are served at what cost? We currently have the following open files: 165 adult conservatorships, 51 minor conservatorships, 322 developmentally disabled adult guardianships, 241 legally incapacitated guardianships, 97 minor guardianships, 223 open estate files, and 40 mental health files. Aside from the estate files, the vast majority of these files have a petitioner, guardian, conservator, or other fiduciary who's acting without an attorney. This means that the probate court serves parties notices, prepares court orders, and prepares other documents that an attorney would normally do. This costs personnel time, paper, and postage. The filing fee for most types of files is $150 by law. 0 of these fees go to the county general fund. Mental health petitions and developmentally disabled guardianship petitions are free to file, per the mental health code laws. Where there is a $150 filing fee, the court is being asked more and more frequently to waive the fee, depending on financial circumstances of the person filing and of the subject of the petition. If the person requesting the waiver of fees is receiving public assistance, their fees must be waived by law. In most types of in most types of cases except decedent's estates, either an attorney or a guardian ad litem, which means visitor or investigator, is required by law to be appointed. These are contracted attorneys whose fees are $60 an hour, which is far less than what they would earn in private practice. This fee for our court-appointed attorneys and guardian ad litems has not changed in 12 years. We do provide our new guardians and conservators with handbooks. These handbooks are available in printed form, or they can be obtained from our website. These cost roughly $12 per handbook if you consider staff time and office supplies. We also provide guardians and conservators with a video if requested. These were obtained by our office with grant monies. Our Volunteer Services Division provides free accounting assistance for new guardians and conservators who need help filing their inventory or accounting. In decedent's estate cases, we do collect an inventory fee. These range from $5 on up and are based on the amount of the assets that are being probated. 47.5% of this inventory fee goes to the county general fund, with the remainder going to the state general fund. For a $20,000 estate, the inventory fee due to the court is $119. The amount that would go to the county general fund in that situation would be $56.52. These are not able to be waived, but there have been occasions where the fee is uncollectible, although this is very rare. Why are these services important? Probate court is a mandated department. We serve people who are indigent, mentally ill, incapacitated, without a guardian, in need of protection, or otherwise vulnerable. Known or potential concerns that could impact services or revenues. The question is whether changes in state legislation are coming soon. After inquiring to our state court administrator's office, we are not aware of any upcoming changes in legislation that would increase our revenue. However, there have been new laws passed that have impacted service that require our staff to do more. Bonding for conservators is new. Bonds are now mandatory in certain circumstances. The court has had to create a new procedure for this. A new court rule is now in effect that changed the way people with limited English speaking skills can access the court. The court has had to create a new procedure for this. New legislation is in effect regarding do not resuscitate orders. These new laws impose more duties on the probate court. Demographic changes that will impact activity or revenue. Baby boomers are aging. This is a popular retirement area. Our numbers are not going to decrease. We will at some point need more staff to support the looming increase in petitions and files. What are potential revenue increases and how much would it generate? Our court is evaluating the possibility of making the following changes: increasing copy fees, charging late fees on guardian ad litem and attorney bills, and billing for attorney fees on mental health files. We are uncertain how much additional revenue this would generate. People may request their guardian ad litem or attorney fees be waived. This is something that we would need to evaluate after a period of time to see if the time we spend attempting to collect these fees is valuable enough to continue doing so. Our court does schedule some hearings as paper dates, which does save some money on attorney fees. This means we don't actually have a hearing on the record. Suggestions for alternative ways of providing current services. What is the potential for outsourcing or merging with other entities? I do not know of any way the probate court could outsource or merge with other entities. How would we implement a general fund budget reduction, and what impact would that have upon services? This question is difficult to answer unless I know of a specific amount that is going to be cut from the budget. Our court would suffer tremendously if we had to lose a staff person. We are already behind with work and struggling to serve the public in an efficient way. In the month of January, we received 901 phone calls. There were only 22 working days in January. This equals an average of just over 40 phone calls per day. While we welcome the public's phone calls, they do interrupt our workflow and generate new work for all of us in the office. This is in addition to the tremendous amount of other work we have. In 2013, we had 493 new files. Because people are more frequently representing themselves and not hiring attorneys, more and more of our staff's time is required to assist them. Which services are not mandated and could be discontinued, and what impact would that have? Volunteer services is an integral part of the probate court. Although not mandated, the value of the services that the public receives far outweighs the cost. Our previous department had requested $2,000 to support the volunteer services department. This was reduced to $1,000. This money is used for trainings, conferences, meetings, and continuing education with our volunteers and potential volunteers and volunteer guardians. The volunteers provide us with free guardianship reviews for minor and adults that would otherwise cost taxpayers. As we have 338 guardianships that have to be reviewed periodically, we would have to hire reviewers to complete these if we didn't have volunteers to do them for free. If we charged for these, some fees may be waived due to indigence. The Volunteer Services Department also provides us with volunteer guardians and conservators for people who are indigent in a nursing home and have no one willing or able to serve as guardian or conservator. These people would otherwise have no one to do so, or a paid guardian or conservator would have to be hired. We want to continue to support our volunteers with trainings and continuing education. For the monies we were given this year to support the Volunteer Services Division, the value of the services that we receive far outweighs the cost. If we didn't have this program, the probate court staff would have to spend staff hours developing a public guardian program. Continuing education for court staff is essential to the functioning of the probate court. Our staff would not be able to do what they are mandated to do without continuing education at conferences. Conferences further our knowledge and help us better provide services. Our state leaders work very hard to provide useful conferences that contain valuable information. And I want to refer you to the back page in your packet that I passed out that is a summary that our Volunteer Services Division put together for us that's an estimation of how much money is saved by the volunteer services program being in place. Are there any questions?
Questions from commissioners? You are all documented imaging? Your files are not documented image, Deb?
No, we have not been approved for imaging.
Speak into the microphone, please, will you, Judge?
When I went to the new judges seminar, there was two things that I asked for down from scale. The first one is I asked them to come and please assess our probate court for us and see if we are running as effectively as we can. I am still to this date waiting for them to come up and do an administrative review of our court to see if there's any way we can cut costs. The other thing that I also said is that, or I also offered, was to be a pilot program to have imaging come up to probate court, and they could use our place as a starting point. I have not heard back from that. I am waiting for that. I know they have not started in any of their probate court, but I'm jumping up and down, willing to take any assistance with that we can get. So those are the two things also that I have done. So.
That'd be great. Dave?
Well, I appreciate that, Judge. Jerry Cole's our regional representative, and Jerry ran the Midland courts when I was there, and he's got quite a few ideas on that, having gone through that trial court next generation project with us. So you might want to tap him, because I think if you don't ask, he probably won't offer his advice, but if you ask for his advice, he probably have some interesting things to tell you. So just that's in response to what you just said. The guardianships and the volunteer service, it's almost sounding like you're asking for the money to be restored. You're talking about it just went from 2,000 to 1,000, but I'm not sure what you were asking or what you were saying with this.
I was referring to the amount of money that was actually given to probate court. The requested amount was $2,000. It was reduced to $1,000 for this year, so that's what we have available to support our volunteer division.
Right.
For trainings, conferences, meetings.
There, and I don't know how guardianships work here. I know that Midland ended up instituting its own public guardian program with a professional guardian. And A lot of counties don't do any of that. They rely on Catholic Social Services or Lutheran Social Services or a number of other places to do those, and they charge those fees right directly to the clients. Now, I don't know if that's, it's possible to raise those dollars through the clients by charging those in guardianship fees. But-
They would, the person would have to have the assets available to pay a
Right.
professional guardian or conservator, and often our people do not, but
They're Social Security. And Ms. Boston is here from Child Services. Perhaps she can give a little more insight to that. She's been doing it for many, many years.
I guess my reason for saying that was that in Midland, as we went through, why do we need the public guardians and what are we going to do if we're going to hire one? Can we make it cost neutral? And it was almost. There's no way to make it perfectly cost neutral. Using volunteers is one way to get it there, but if you're going to run a program with a professional person doing it with secretarial staff or whatever. Even though she was not, well, I'll just leave it at that.
I will state, first of all, it would be the responsibility of the GAL as appointed when a petition is filed to identify in interviewing the family any interested person who would be willing to act. We also are kind of becoming a little stronger with regards to accepting petitions for guardians and conservators and asking them to identify interested persons. And this is where volunteers have been able to respond when no person has been identified to act. I will say that over the last few years, some of the assignments that volunteers are taking on are great. And they are more than what we would have initially put in place as the description for what would be an indigent person who has lesser funds and is, say, in long-term care where those types of responsibilities are being managed on a regular basis. A guardian is appointed to take care of personal types of decisions, medical as well, and of course the conservator then for receiving the monies. So we're talking about typically the ideal situation would be to have volunteers involved when there are fewer funds and the people are in, say, long-term care or in those types of situations. That really is not the case today with the numbers of cases. And I bring that to your attention because the judge and I have talked about how we are going to have to look at some changes with regards to how we're going to handle these cases because of the depth, the need, the number of hours, and the types of cases that they are. A 21-year-old developmentally disabled young man takes an awful lot of time and energy from a volunteer in managing their lives and
I
making
know.
all of those situations that happen. And I think statistically you can see we have been covering that need, but that's not to say that we aren't pressed. That's not to say that CMH and some other agencies would like for us to do their work as well. And so we are being pressed, and we will be looking at that. But thank you for recognizing the importance of that value. Really, the sheet that we've handed out does not begin to reflect what exactly that they're doing
Oh, I know. I
in
mean,
any way, shape, or form. I think it says
whatever it
60...
takes to live is usually what
Oh, my
you end
goodness.
up doing.
Yeah, I think it says 67,000 or something to that effect, and that's not anywhere near the time, of course, it's being mandated really by the needs of the board.
Other questions? Larry?
Two quick ones. So is it my understanding you're attempting to evaluate a juvenile drug court?
Oh, that's not probate court.
That's not probate court.
That's the next one.
That's the next one coming
Are
up.
we ready to move on?
And that the child care fund would have to deal with the other one as well? All right, okay.
One more question, if you would. Have you taken a look at the website to see what frequently asked questions, what kind of data can be put on the website to make, those numbers of calls drop?
we have a very extensive website that has forms, instructions, links, agencies that can help. We're
Each
considering...
of the calls is individual and pretty hard to answer in a generic way. It's we got to look up your specific information to answer your question.
We have people who call with questions about their file or why their account needs to be corrected. We have people that call requesting legal advice, which of course we can't provide. We have just a lot of needy people that have a lot of questions. They have a lot of legal questions. They want to know what our procedures are. And we do have to spend quite a bit of time on the phone with them, and there often is just no way around that. And because we all like people, it's okay with us. It's just that
Sure.
it takes up an awful lot of our time.
Yeah, I mean,
Yep.
as the aging population gets a little bit more technically proficient,
I know Christine Maxbauer is not here, and she's on the Commission of Aging, and I was on the Commission on for Aging prior to being elected, and it's anticipated by 2020, over 1/3 of our population is going to be over the age of 65. So we know that we need to become prepared for it.
Commissioner Inman is also on that committee.
Yeah.
Oh, you are?
Yeah.
Oh, we were just,
I only got 1 year under me. though.
oh,
I'm a newbie.
you're a newbie. Well,
Yeah.
well, congratulations.
Are there any-
I think all of us will qualify in that category.
Are
too.
there any fees, I
Some of us
noticed that
already
you
do.
said you collect $119 and for fees for the decedent's estate cases. Is there any way to increase those fees? Are there any ways to increase the fees for what the volunteers do to help pay for additional funding for the volunteer services?
guardian services.
The decedent's estate cases, the inventory fees are dependent on how much is in the estate.
Okay.
So not every person that passes away has an estate that needs
Right.
to go through probate. The ones that do, they can be very minimal, $5 on up to 1,000
How
something.
much do we collect on that on a yearly basis, do you know?
I could run a report to find that information. Only a portion of that goes to the county, the 47.5%. And I'm sorry, your other question about volunteer fees?
Is
What was
there
your
any way
question?
to collect fees for
Guardianships
the
and
work the
conservators.
volunteers do to help pay for some of the training and programs that need to be done for the volunteers?
Boy,
When you don't have volunteers, you would be charging those, other than the indigents.
They're no longer, in that scenario, they're no longer volunteers. They would be public
Well,
guardians
but the-
or being,
I guess we're talking about the fees that, the $1,000 that you talked about, saying you got to cut from 2,000 down to 1,000. Those are dollars that the volunteers use. You could maybe charge their travel. You could give them some incentives to do maybe even more work for them, so that they're paid on a per duty basis. Say they're keeping checkbooks or going to the, all those things, just think outside the box, and there's ways to structure it for each case,
Yeah.
is what I'm trying to say, and it will enhance the guardian and conservator program.
Yeah. Just because we cut you, that doesn't mean you can't figure out how creatively to
Yeah, we don't
increase
take
some of
your
those
own, we want you to
revenues
use
to
it.
be able to compensate, to be able to bring some of that money back. I guess that's what I'm trying to figure out, whether or not that's possible. Just a question.
Yeah.
So, Sonny?
I guess I have a couple little things. One,
sure.
I sometimes have a real tough time with the definition of indigent, because I've seen people categorized as indigent that damn sure have the ability to pay if they wanted to. So we need to make sure that the people that we are writing off as indigent that we cannot collect for are absolutely unable to pay their bill. Because there's a lot of folks out there that will tell you they can't pay their bill, but they can have a lot of toys that they don't have any problem using.
We have seen that. We do ask them to fill out a detailed form that lists not only if they're on public assistance, what their case number is, but also the number of dependents living in their household, their obligations that they pay out every month, their assets that they own. It is pretty detailed, and a lot of our people are living on Social Security. So that's part of it. The other thing is that, again, if they're on public assistance, their fees have to be waived by law.
Unfortunately, personally, I think there's a lot of people on public assistance that shouldn't be there, but that's not a thing that we can fix in this room today.
Right.
You're identifying 4 people in staff and identifying 7 people in the room, so I'm just kind of curious about that.
Childcare.
Walk into the microphone, please. It doesn't bite anybody.
no, I know, I agree, I'm a walker.
Yeah, I know.
This is probate court. Amanda works in probate court. All the rest of the people here work for the family court,
Okay,
so which we will get to next.
I'm sure.
Okay. Any other questions?
I guess the only comment that I would make is, I've been around long enough to have seen some of the work that the the CASA program and the volunteer organizations do. And, you know, I can't speak highly enough about the services they provide to people in our community.
So, incredible. You know, I don't know if the people in our community really understand all the work that we do for the people in our community.
Don't have
And
a
it's a
clue.
great service that we provide.
I agree with you.
Yeah. Are there other questions? Thank you.
Now, Ms. Conklin will present the information with respect to the family court.
Hi, I'm Diane Conklin, and each of you has a pamphlet here that you can read later on, but it explains some of the volunteer services that we do in the family court side. It explains the juvenile sobriety court, the juvenile behavioral treatment court that we have, some of the probation offices, and some of the classes that are taught by them. It also has a list of the fees that we charge for attorney fees at the end, and that fee schedule has not changed since 2003. So we have not increased the amount that we pay attorneys or that we charge to the people for those services. So we'll start. Some of the services that we provide in family court, we have the child protective proceedings, which are the neglect and abuse cases. We have adoptions. We have the juvenile delinquency matters. We have divorce with children. Judge Stanton handles 50% of all of those. We have paternity support and custody cases. Judge Stanton handles 100% of all of those. Personal protection orders, again, it's 100%. And then any name changes and a few miscellaneous items come under that category. 40% of all domestic cases that are filed in this day are support or paternity matters, and Judge Stanton handles all of those. There was a case study done by Scale, which we received just a few months ago for 2013, and it's called a weighted caseload report, which determines like how many minutes are needed per case type. The 7 most intense case types, 5 of those are in probate and family court. And so as a result of that case load that Judge Stanton carried for 2013, it would take 1.74 judges to fulfill those cases, and she does all of them. For the circuit court, they had a judgeship of 1.34 judges, and that includes all of the Grand Traverse, Leelanau, and Antrim cases, and 2 judges handle those matters. In district, there were the 3 judges, and they handled the work of 2.12 judges for the 3 counties. We had 1,700 hearings just in family court. That does not include the ones Amanda has in probate side. We had a 54% increase in all neglect and abuse petitions filed. We had a 31% increase in the delinquent youth that were adjudicated last year. For our total caseload, we had domestic cases. Now, these aren't verified. They will be verified by the end of the month with Kathy Cook and Family Court Records, but we have 408 domestic cases, and then delinquent abuse and neglect, 398. In all of our family court departments, we had 21,617 phone calls to our court for 2013. This is a breakdown of our staff. In administration, we have 6 people. We have 5 probation officers, 1 judicial assistant. As you can see, she's only half-time. The other district judges and circuit judges all have a full-time judicial assistant. We're the only court that has a half-time person. We have a therapeutic coordinator for our sobriety court and behavioral treatment court. We have a truancy department, which Ms. Heather is the coordinator for, and she has 1 staff person. And then Linda Fawcett is the volunteer services, and she has 2 full-time staff people and 1 day per week staff person that handles the learning partners portion. And this is a breakdown of our budget. For payroll and benefits, you know, those are the amounts up there. You can see the $1,167,000. Our operating costs, $120,000. Our contract services, which includes our JIS system, which is our reporting system on the computer to the state. Our BIS is our court recording equipment. Our SCAO drug court grant providers for our juveniles come out of this line item. Process servers, that's $38,900. Our court costs, that's our transcripts, jury fees, witness fees, attorneys, GALs. You did give us more in our budget that we requested for our GALs this last year, and we're very grateful. You increased it to $75,000, so we can give a little more to our GALs than they received the last 6 or 7 years. And then our attorney fees, we went over in the budget in that line item last year, despite our best efforts. But, this year, I don't know. We have $60,000. Last year, we spent almost $61,000. And so it's going to be close because we have, as you saw, the caseload with all those hearings we have to pay those attorneys for. We have miscellaneous services of $11,000. Repair for equipment and vehicles. We do have 2 vehicles in family court. One is a van, one is a car, and the volunteer services use those to transport our juveniles to different facilities. And then our probation staff also uses them too. We take kids to a challenge camp called Mid-Course Challenge Camp during the summer, and we use those vans for that.
How old is that van?
2005, I believe, Dean, is that correct? 2004, 2005?
10 years old?
Oh, I wanted to go back to that one. If you see on the bottom, the Child Care Fund pays a large portion of our personnel, $461,000 for personnel. That covers 13 different employees are either totally funded or partially funded through the Child Care Fund. And this is our Child Care Fund budget. And we're on a different fiscal year. It starts in October and it ends in September. This year we asked for $300,000 in foster care, $625,000 in institutional care, our in-home care program $791,000, and independent living $1,500. Of this amount, the revenue expected is $120,000. We try to utilize the in-home care program as much as possible. That's the part where we use the volunteer services, we use intensive probation, we use our therapeutic courts, the CASA program, Learning Partners, and we try to keep the kids in the community as much as we can, as opposed to just sending them to an institution. That figure alone for 2 children last year that were in institutional care was $180,000. One child was $9,000 something per month, another child was $5,000 per month. So that's what we try to avoid by utilizing the in-home care programs. And I'm going to speak some more about that later on because we do have some new programs we've started as a result of the money from the Child Care Fund for this. And these were children that were served in the last fiscal year for the Child Care Fund in CASA. We had 70 youth, experiential learning. We had 74, community service 77, intensive probation 70, the treatment courts 49, and truancy 308 youth that Heather oversees in the different school systems. We had 25 youth in foster care last year for 4,051 days for $261,000. I had $8,000 some dollars left in the foster care line item when the year was finished. That can range anywhere from $17 a day up to $60 some dollars a day, depending on where the child's placed. If he's in a licensed home, if he's in a private agency, if he's with a relative placement, they're all different rates that they charge. We had 56 youth in institutional care for 3,296 days last year for $648,000. That's the number that we're really trying to cut down on. The 2 youth that I talked about that were the $180,000, they're no longer in our program any longer, so we don't have anyone that's in that $9,000 range. Well, we have a young man that went to a sex offender placement, and so he may be $300 and some a day at one of those, but we review those every 60 to 90 days. We don't just put them there for 9 months and say, here you go. We bring them back for review hearings. The referees and Judge Stanton take a look at that, see is that program meeting their needs, how are the reports, are they doing well there, and then we determine whether they stay there or not. We have several grants that we oversee in family court. The first one is the Juvenile Accountability Block Grant, and that one runs from April through March. Of that $32,833, we share it with Leelanau and Antrim County too, and we all report monthly on that grant, and then I oversee that for this grant. Grand Traverse County receives $19,048. For the next coming year, we got a little bit of an increase. We will be receiving $33,788. In Grand Traverse, the portion we will receive will be $28,708. This we use for drug testing mainly in the JAB grant. That's the way the grant is set up, and that's what we use it for. There's a little bit of administration in that, but it's mostly ATS, Redwood Laboratories in California. We average over 100 some drug tests per month, and that's where the money goes. The federal government said that the JAB grant may not be renewed after 2015. It's probably very definite that it won't be, but we haven't received that in writing yet. The SCAO Drug Court Grant is one that Cherry Wolf and Finance oversees the financial end for us. That one, we received $62,000 this year. We asked for that, and we got everything we asked for. In the prior year, we received $32,500. But Judge Stanton, when she came in, one of the things she really wanted to do was to start parent support groups. And so we now have active parent support groups in the behavioral treatment court and in the juvenile sobriety court. So the parents are mandated to go to these programs to learn about parenting with licensed counselors every week. And so both of those programs are paid for. One, the behavioral treatment from the Child Care Fund, and then the SCAO grant pays for the sobriety court one. Revenue, we have $124,000 in our probation oversight, attorney fees, drug testing, crime victims fund, collection and transportation fees. In family court, at this point, every fee that we have, that we pay for, we charge it back to the parents and the youth. And Mandy's going to talk about that in a few minutes for our collections, but that is what we do. We bill back every single bill. We bill back the drug testing if it's not paid for from the grant. We bill back attorney fees. We bill back detention. We bill back foster care. All those fees are billed back to the parents or the youth in some cases. Our child care fund, we brought in $113,000, which was 42% of our budget total for revenue. Restitution was $9,200, representing 3%. Our filing fees, copies, civil motion fees was $18,977, and that represented 7% of our total revenue. Some court savings, specialty courts. Our juvenile sobriety court and behavioral treatment court, and we are only one of 2 counties in the state that have a behavioral treatment court for juveniles. We have our average detention days for a traditional youth is 10.5 days. Our average detention days for a sobriety court or specialty court youth is 6 days. So that's a savings of 4.5 days of detention. At an estimated $170 per day times a 31 youth, that was $23,715. For juvenile probation, we have an electronic monitoring system in the homes. Those youth have that tether. There were 75 tethers from 2011 to 2013. Normally, they were put on tether for a minimum of 30 days. But if we use the 10.5 average that they would have been sent to detention instead, there was a savings of $133,000, and that's a pretty low estimate. It was probably more than that. 5 juvenile probation officers last year saw the youth 2,473 times in 2013. Also, we started a program with, it's called Satellite Tracking out of Houston, Texas. For $4.25 a day, we can put a GPS-type tether on a youth. So that's what we've begun doing. We have, I believe it's either 2 or 3 youth now that have that tether on. The one that we used before was just in the home, so we could only track if the child was in the home when he was supposed to be. This one, we know where he is at any given moment. And so the probation officers are able to set it up when they want to monitor him throughout the day. So they know if he's at school, they know if he's somewhere else, and they can track him that way. So for $4.25 versus $170 a day for detention, we're looking at some different alternatives. We also had Barb Donaldson and another probation officer went to anger replacement therapy training. So they are now qualified to teach that class to our youth. We have New Vision Academy, which is one of the groups that Linda oversees in volunteer services. That teaches life skills every summer to at least 20 to 25 youth. Those are all, volunteers come in, it's no cost. Thinking for Change is a type of behavioral modification that our probation officers have been trained on, and now they are doing the training to the youth. We aren't paying outside people to come in to do this job. Our own probation staff and our volunteer staff are doing this work. Heather's going to be trained later this year in parenting with love and logic, and then she'll be able to teach that in our courts. We have, as I said, the parent support groups. And then this is, Linda, this is the one with you that you had for your savings for the different programs in the volunteer services. So if you have any questions on these, Linda can come up and speak on these. These are some of the different things that go through volunteer services, the transporters that take the kids to the detention centers, the New Vision Academy, SHOCK. What's that one, Linda? I don't know that one exactly. Oh, that's right, the shoplifting is a crime. In the 4th grade, correct? You go into the 4th grade students. In conjunction with Macy's and law enforcement, correct, okay. And then we have the citizens panel that oversees some of the children's cases if it's not a serious offense. Did anyone have questions on that for Linda on this part? Some changes in 2014. Amanda referred to the one with the language access plan that we are all now required to have. So we have to provide interpreter services if someone needs it. We have not had to use that yet in family court, so we don't have a clue how much that might entail. If the person has the ability to pay for it, we will be able to bill that back. But once again, we'll have to look at that and see what their ability to pay is. We are seeing an increase in the severity of cases coming through family court. A lot more sex offenders this year, weapons cases, where we don't have the ability in our community to deal with those youth on a lot of these. And that's why some of them have to go to the residential treatment that's more expensive. But we do everything we can to keep them here as long as we can without that. And then, Mandy, would you like to come and speak about the collections part? We did implement one new part for collections, which we've never done before in family court. We're going to be charging a 20% late fee, effective April 1st. So if a bill is 56 days past due, they will be added a 20% late fee charge at that time. It will only be added once.
Thank you, Diane. I'm Mandy Lear, and I work on collections in family court, and it is a job. It is a lot of work because it is such a unique situation. If you would flip in your blue folder to the 3rd to the last page, that's my summary of what I'm attempting to do and what we're faced with in family court. This is not on a PowerPoint, but it is on your page. And I began with the fact that our collections process is very different from the criminal courts process. Having worked in the criminal court with Judge Power, actually, I've seen how the fines and fees and typically, if in a criminal hearing, a sentencing, the person is told you've got $200 costs, $350 fines, restitution, and this is how much it is. In our case, in family court, in delinquency cases, for example, there is a dispositional hearing called, like the sentencing, where they do get fines and costs, but then parents are also facing however many months or years of detention the child goes to if they are sent to detention. So, for example, a parent, their first bill for the first month might include $25 probation fee and their little fines and costs, but then the child goes off to detention, and the next month their bill is $9,000, and the next month it's $18,000, and the next month it's and so forth. So we have some huge bills because we do charge every dime back to the parents in delinquency cases. We also charge every dime back to parents in neglect and abuse cases. So if a person's children are put in foster care, and foster care can run up to $65 a day, and can last for up to a year, I think, or more. We divide it between mom and dad. You're looking at thousands of dollars there. And most of these neglect and abuse parents, as you can imagine, are either struggling with a substance abuse problem or they're homeless or very few resources and hard to find. They can be, you can have a case where you can't even get an address, and once you do, you send something and they're already gone. So this is a very interesting collections problem. We have one dad that owes $113,000 in detention fees from his child being in detention for months. I shouldn't say years, months. We have neglect and abuse parents that call me and say, you know, I'm living at Safe Harbor and I can't make a $25 a month payment. So we are re-examining our philosophy and trying to come up with what is effective for bringing in more revenue, that's our goal, effective for keeping parents accountable. They're costing a lot, their children are accruing fees that the parents are responsible for. We ask ourselves, the three of us, are we running these folks off by sending them these, you know, when they're getting these bills, would we be more effective to make them actually possible to pay off? And in this process, I have been calling around to other counties, including Midland. I didn't realize that that was your county. And I'm finding a lot of counties do not charge neglect and abuse parents anything. We're not sure how to approach it, but we are looking at different possibilities. At this point, we take in between $22,000 and $25,000 monthly. We have 250 bench warrants out. Those are folks that are off the radar. We have 100 orders to intercept state income taxes, and those are starting to come in, and that is brand new, and I think that's going to raise our revenue. Like Diane said, we're going to start charging the late fee for anybody over 56 days that has not paid. We have 50 payers that are in prison. We are considering writing those bills off if they are long-term prisoners. We have 160 payers that we simply cannot locate, 55 payers living out of state. We do not issue bench warrants on those because we don't plan to transport them back here, and 50 payers that are basically in and out of incarceration or rehab, which leaves us with about half of our payers that are actually locatable and collectible. A couple other ideas we have for the future. On my second page there, we're considering using more of a sliding scale or a flat fee rather than the bigger bill every month idea. A lot of counties are using a flat fee and finding they collect more when it's doable, when folks feel like I can actually pay off $3,000 instead of $38,000. We're considering writing off the bills of prisoners, long-term prisoners, that we do have the ability to garnish anything they have in their prison account over $50, and every one of those I have garnished, but it's usually, if anything, it's $5 a year that we see maybe from prisoners. We're considering writing off more accounts that simply seem to be uncollectible. We are looking into booting vehicles or restricting driver's licenses of folks that are not paying. Have not come across a county that does that yet, but I've heard Ingham does, and we're going to check with them. I'm going to pursue more foreign judgments registered with the tribal courts. I haven't had a lot of luck doing that, but I did have 3 that were registered last year, and we were able to collect on their per caps. And we are looking at giving parents, we already allow parents to transfer their balance to their 18-year-old at the judge's decision if the parents have done their part paying and they still have a balance. and then giving the adult who was the child, who was the delinquent, giving them the chance to work that off by earning first their diploma and then each semester of college, along with paying monthly, possibly writing off a percent, hoping to help the kids get moving. On the last page, you can see the form we give to everybody when they start a new case in family court, just to summarize what they may be looking at for costs. It does not, however, tell them specifically that, detention can run up to $320 a day and foster care can run up to $65 a day. So I do think folks are very discouraged in some of these cases. Do you have any questions for me or for Diane about our family court
Go ahead, Larry.
presentation?
Is this the time to talk about your looking into a juvenile drug court? Is that the time now to talk about that?
We do have a juvenile drug court.
All right. I wanted to make sure you did have one.
Oh, yes.
I haven't heard.
We have had one.
You
We have-
do have one.
We do have one.
Okay.
And that's where we get the JAB grants from to do drug testing for that. And we just got money back from Scale. We started a parent program so that they have to come to it afterwards, because a lot of times, when your child's in court, let's face it, usually there's chaos in the family. And we focused for years and years on just the kids, and now we're trying to look bigger than that and try to bring the parents in, so perhaps we can do some settlement within there. We just started those probably about 3 weeks ago, 4 weeks ago, and it has, the response has been overwhelming from the parents. So we're hoping to get a trickle-down effect and see that in the children.
I've just heard nationally that counties that have gotten in the big thrust at the beginning was to have alternative courts for district court, and some in the circuit. And, but nationally, the fight for county commissioners nationally at the National Association of Counties was to get them in the earliest stage possible, when they're going through, about to go through or going through the juvenile court system. And, if we can curb the impact going forward by addressing it earlier. And I don't know if you have any comments to that, whether that you're seeing that, it's maybe too early, I don't know.
What we're doing, when all youths come in, it's usually related to some kind of substance. But we have screening tools that we use to determine who are our most high-risk juveniles, so that we can give them the services to keep them out of the system. The thing with juveniles is we are testing for alcohol, marijuana, cocaine, and things of that nature. They use a lot of designer drugs that aren't necessarily able to be tested. And if we did want, pardon?
Hairspray.
Hairspray, spice, things of that nature. So it's very, very difficult for us to objectively measure what is an appropriate measure to make sure our teens are being successful. In fact, we are going down to a drug conference in 2 weeks, and on the juvenile portion of that is going to be my big question to all these researchers out there: what do I measure? Because it's very, very difficult. Heroin's now back out on the streets again. We're seeing a lot of kids with LSD and mescaline. They have a very small window of opportunity for us to test for that. I think it's less than a 24-hour time frame. So it's very, very difficult to proceed forward. But so what we're doing is trying to start from within the home, change the behaviors within the home, and hopefully it'll change with the children also. The biggest problem is a lot of these behaviors and the problems started years ago. And to me, that's a whole nother topic, but that goes back to the truancy issue. We were just down at a summit in the fall, and we're looking to define what truancy is, because as you're aware, every county, every division has a different definition. But it was all ISDs were down there, a lot of the 70 of the courts were down there to try to come to some kind of conclusion what truancy is and how to address that. Once we got a definition, perhaps that we can, through the ISD and through the Grand Traverse school system, is come up with a program in which we can grab the parents and the kids at a younger age, so we can start working with them then when we can make big changes. I think our learning partners, that's what they do. They get in there with high-risk kids and they teach them how to read and do the things that we do. Because a lot of times by the time the child is 13 years old, 14 years old, it's very, very difficult to change those behaviors. So I would like to even look at going down even farther with respect to juveniles. So the next question is how do I do that, because I don't have authority over adults. I have been in contact with Judge Phillips, and because the district court handles truancy issues, he would be willing to do concurrent jurisdiction with me, and I would be willing to handle those I would be willing to handle those, to have an actual truancy court that can start at a younger age. They know that the truancy patterns for children start as early as first grade. The first grade, second grade, and third grade are the big 3 years that we need to make the biggest impact. So those are the kind of things we're looking forward to.
Yeah, and I just bring that up because as the county continues to grow and we see more activity, staying ahead of the curve, especially when they're younger, and if you correct their behaviors or get them into a different environment, that's going to save us in the district court and circuit court area, jails, those kinds of things. And so I'm happy you're doing this, and I don't know if there's any cross workings you can do, because I know you got differences between contact with adults versus juveniles, those kinds of things. Probably it's kind of difficult to cross work those with the same courts that we have going on now with district court and juvenile court, whatever. But you're probably working with the same providers maybe, but they're not intermixed. But I guess the question I have for you is the impact on school liaison officers when they weren't assigned to the schools and when they were, getting ahead of the curve in terms of having an officer at the schools, being more on the offensive side of things rather than defensive side, trying to correct it later. I mean, your viewpoint on the necessity of having those officers available in the schools and trying to correct those problems to the degree that they're able to do so, and the impact on your court.
Well, just so that you're aware, on our mental health court and our sobriety court, we do have one of the liaison officers that does come and participate at our team meeting at lunchtime.
Right.
And it's very important. I view them as a positive thing within our community. I know some communities do not, because I think they're trying to, bring criminal charges against the kids. That's not been our experience. And what I'd really like to address that is Barb Donaldson, and this is the reason why. Liaison officers they just came back on. They were gone for quite a few years.
Exactly.
So I don't have the comparison and can't give you that. But I think that Mrs. Donaldson probably can, and will be willing to answer that question.
I think that would be helpful for us.
Good afternoon. My name is Barb. I think having law enforcement work with our probation department and our court system is a huge, wonderful impact. When the police officers are in the schools with the children, they are able to talk about issues that come up in school, issues that they have that are personal, and they begin to view law enforcement as an asset to themselves, someone that they can go to and trust, and they work so closely with our probation department. For example, if we have the authority to go into a home and look in a child's bedroom, in their drawers, under their bed, and in all their belongings, and actually do a search. And all we have to do is get law enforcement to assist us, and they're able to do that. And they can't do that unilaterally. They have to have our permission, because when they come on probation, they give up that right. So the partnership is just wonderful. And I've seen kids in the hallways at school actually go up to the officers and greet them. They have lunch with them, and it just opens doors of opportunity for rehabilitation. And I think that The teachers, the principals, I appreciate them. We have communication with them weekly, daily, so it's a wonderful thing, and I'm proud of what they do, and I'm proud of our court for wanting to support what they do and work together with them.
So you think there's a big impact of having them there in the schools versus not having them there?
Absolutely.
In the
Yes, and like Judge mentioned, it isn't the idea of going into the school and trying to find crime. They're going into the school and trying to prevent it by being positive role models and really working with the kids. And to see an officer fully uniformed sitting in the cafeteria with the kids, it's a wonderful thing. So I think they're developing a sense of respect for law enforcement, which we need in our community.
All right, very good. Thank you.
You're welcome.
Seems to me I saw a video not too long ago about somebody when they went into a kid's bedroom and how the parents couldn't find the drugs, but you guys knew what to look for and how to look for it. And it was amazing.
All the hiding places.
Oh, my gosh, yes. So I don't remember who showed that video, but it was like a year ago. I remember seeing that. And it was like, oh, okay. So I think, you know, those officers do know that and know what's going on. My question I have is, when you have all these people with all this debt that they might owe, is there a way that they could be able to use some volunteer hours to be able to work that debt off? And I know we have our probation people that are using volunteers, and right now they're having trouble filling all the slots. But I just wondered if we can't work this, internships or volunteers.
Yes, we have offered that in the past. The folks never followed through, in my experience. I've only been here 3 years, though, and I have not made it maybe as widespread as, like a big announcement. Maybe we could look into making it more available. I've offered it in the past, and they just never called the person they need to set up. But it is a good idea, yeah.
I think you need somebody that controls it in order to be able to do that. I mean, you just can't expect that they're gonna say, yep, I'm gonna do it, and then there's no follow through. And I'm sure that would take another person in your staff to be able to do that.
We do, yeah. I gave them the name of the gal who coordinates it for the juveniles, and they didn't we do have a population that has problems following through, even the parents too.
Sure.
So, not all of them, but a lot of them. So, but yes, that's a great idea to offer more.
Okay. Sonny?
Well, a couple things in regard to that. One of the things is these juveniles got into a problem probably because they didn't have the proper leadership before they became young adults or whatever the situation is. A first, second, third grader that has a truancy problem, that's not something that the parents shouldn't understand if they know what's going on. My wife worked for a number of years at the school system with at-risk kids. I remember at one point she had a class with 17 kids in her class that were on tethers. If somebody doesn't show up for the class, you don't call the parents, you call the sheriff. But I also know how many times she went to court with those kids because the parents wouldn't show up. We take these kids and we send them away to structured institutions. Which I'm not sure that I completely agree with, but they're not getting what they need to be at home. The problem is they go to those facilities, Shawana, wherever, and they come back with, structured things. You will get up, you do this, and this. They come home, their parents aren't home, they're single-parent homes or whatever the situation is. They don't have any guidance at home, and they still have the same friends that they had when they were in trouble before. I certainly don't have all of the answers, but I certainly know that we're not going to cure this unless we can change the home environment.
Right.
And, we used to joke, and the sheriff's heard me make the comment lots of times, the names in our jail are the same, it's just the birth dates change. And if we don't do something about changing the home environment that these kids are in, we cannot cure the problem long-term for our community. And, you know, I give you a lot of credit for trying that, but we have to figure out better and better ways to involve the parents, but we have to make the parents responsible. You know, and it's not just the fiscal responsibility. You know, we have to figure out a way to make the parents responsible. Now, sure, there's kids that are 18, 19 years old that they go off and they do something on their own that their parents certainly can't control. But a third grader that's cutting school, that's not something that the parents shouldn't have a responsibility for. Or the shoplifting and some of the other things that are going on.
And I agree with you 100%, which is a reason why I think that if our truancy was redefined what it is, how many days a week it is, or a month it is, and we could bring that to the court, so we could provide that structure. Ms. Prevost here and also Ms. Donaldson, we have, in our mental health court, we have quite a few people that are there because of truancy. And it is amazing the successes that we have had with those children in that court, because we bring resources to the family and we provide services. And it's been fabulous. Changed kids all around who didn't go to school that are now straight A students. So it's there. I like my rose-colored glasses. Please don't take them away from me, Mr. Wheelock. And I will strive towards trying to get concurrent jurisdiction so we can maybe address it a little bit sooner before middle school. So.
Charlie?
Hi, Judge.
Hi.
Talk to us about this register of foreign judgments with the tribal courts. How big a problem is that?
That would be our collections?
Well, I honestly filed, the only ones I filed and did not hear back for a year and a half. So it is a big problem, and I'm not sure how to, multiple phone calls, emails, and finally contact with several county departments and got something rolling. But, I asked myself, by the time they got around to filing it, the filing fee that Grand Traverse County had sent to them, the check was void. So we had to reissue, everything had to be redone pretty much. And so we're looking into how we could maybe get more done that way.
Is there quite a bit of money there?
Yeah.
What kind of number?
At that time, I added up how many tribal members we knew that were owing us, and that was a year ago, and it was close to $300,000 at that time.
Is it worth going after this money?
Definitely.
So what can we do to expedite this?
Dave, I think that'd be a good conversation with you and the tribal chairman.
Put a 2% grant in.
Yeah.
To pay it off.
Yeah, thank you. Other questions, Charlie?
I have another question for the judge. What is the impact of the lack of economic opportunity on all these programs in this region?
Huge.
These kids.
Huge.
They have nothing to do.
Huge. And it's not only the lack of economic jobs, it's the lack of resources in this community. I no more want to send an 11-year-old down to Shawano than I want to, it's crazy. But I have nowhere here in the community to send them. I don't have a day treatment program. I don't have a juvenile detention treatment program so that I can hold them for less than $300 a day or $125 a day. It's missing, we need it, and just by the number of petitions being filed every year, our demand's going to go higher and higher. So it is a huge problem. Finding pro-social things for kids to do, to get involved in. This is another thing that we're looking at in our court right now, in our treatment courts. While the kids are with us, we can get them all sorts of services, and we can get them to boxing, and we can get them to do all the kind of things. But after, unless it's being paid for by the court or the child care funding, it goes away because there's nothing out there for them to do. There's no services that come forward to provide us with services to help us with that. And that's another area that I hope to look at in the next 2 years to try to develop those so that we can have things available. I want the kids, if they're going to play basketball when they're in my court, I want them playing basketball when they're out of my court a year or 2 years later. that's what's going to keep them off the streets and clean. So, again, it's a work in progress. I think we've all identified the needs, and it's how we're going to get there. So,
Denise Busley contacted me and talked about an AIM program at the schools. It'd be interesting, I think you might want to have a conversation with her about that.
I don't know, what is the AIM program about? I'm not familiar.
Apparently, it's when a child is immediately charged and put into the court system rather than going to the principal taking care of the issue. And as soon as they become part of the court, they become part of the problem immediately, and it goes on for the rest of their life. So it's just, you might want to have a conversation with her about it. So just a thought. So, you know Denise.
Yes, I know Denise.
Yeah.
Ms. Prevost, have you heard anything about this program?
No.
Come on up. She's on the prevention side. She is the court. But
Yeah.
guess what she's doing? When
So-
she's in there, she's not there to bring the kids into the court. Tell them what you do.
That sounds like the school to prison pipeline to me, which is the summit that we went to in the fall. And I haven't heard of that program. That's certainly something to look into. What I do is I'm a prevention worker, and I go into the schools and we set up these plans. I meet with the parents and the administrators and also the students, if age appropriate. And my job is to keep kids from going to court. A lot of times, discipline, attendance, all those things are looked at in grades. And we develop a plan. The students then meet with somebody at the school weekly that works as sort of a mentor. And then their attendance and grades and behavior are then reported to our office. Hopefully, things improve. If they don't, we move on to the next stage in the truancy process. And we move at the principal's discretion.
Cool.
And you have to understand, Chairman Lemkool, the only time we hear about truancy is when it's reported to us.
Yeah.
And truancy issues. And that's the gap that the summit was trying to fill, to get the schools and the courts to start communicating with one another so we can intervene at a younger age. So that's why we need to have a universal definition of what truancy is. What is it currently?
10 unexcused absences in the state of Michigan is considered truant. But they were looking, when we went to that school summit, they were talking about 2 absences every month. So they're looking at tightening it up. Right now, I mean, some schools are reporting an unexcused absence, as an ill absence. I mean, it's defined at different schools in all different ways.
Sure.
So we need a uniform definition. That's really what we're waiting for.
Yeah. We're going to have to, we still have one more presentation. Do you want a
I
question
guess
there?
the only comment that I would make, this isn't a new problem.
No.
And I think we all realize that. We looked very hard at building a juvenile detention facility here probably 10 years ago, Dane?
Yep.
Yeah.
Probably, and we actually identified sites and started putting together programming and just decided we flat couldn't afford it. It wasn't that we didn't have the need, we just simply couldn't afford it.
Well, I do know that if we did have one here, we would be used by quite a few of the surrounding counties to house, so it may in the long run pay for itself. I haven't crunched any numbers or looked at it, but other than Roscommon and Muskegon, those are the 2 closest to us. So.
Thank you very much.
Thank you.
Great staff, great presentation, appreciate it. Thank you very much. Judge Powers?
So you're going to have Dave look into this, or what are you going to do?
Judge is like, what?
Dave?
I'm just here to answer questions.
Or what?
Okay,
Okay.
all right. No problem. Thank you, Dawn.
Hi, everybody back?
Welcome.
Thanks. I thought I might wait for Mr. Wheelock.
Oh, so you took that
Are they waiting for a while, is that what's going on?
Sonny had to,
You want me to go ahead?
go ahead.
Okay, all right,
Sure.
thanks.
Yep.
So I guess in preparation for today, I did send some materials ahead of time. We had just finished up
kind of a synopsis of all the Friend of the Court activities for 2013. So you have sort of our year in review report, talks about what we did last year at Friend of the Court. Also, a little bit of a cover memorandum just explaining the work that we do at Friend of the Court. I'm sure you're all familiar with that. Essentially, the Friend of the Court work is defined by statute. What we do is defined by statute. So I just gave you an overview of that in that memorandum as well, just so we wouldn't have to repeat all that today. As far as budget is concerned, the Friend of the Court budget is run out of the 215-141 fund. It is a restricted fund. Friend of the Court, due to legislation back in the early 80s, I think it was, has a restricted fund. This is largely because most of the revenues that come from sources other than county's contributions are restricted in that they must be spent on Friend of the Court activities. So these revenues that come in need to support the activities of the Friend of the Court office. We have been on a pretty stable expenditure level for the last few years. In fact, 2010 Friend of the Court expenditures were a total of $1,995,000, and this year, which isn't completely closed out yet, I guess, but it looks like at this point, Dean, our total expenditures for 2013 will be $1,952,000. We're actually about $40,000 less in expenditures over the last few years. Revenues that come to Friend of the Court come from a variety of sources. This is how we meet that expenditure level that I just mentioned. The most significant item in our revenues is the cooperative reimbursement program. You may have heard of that through the prosecutor's office as well. The cooperative reimbursement program funds 66 2/3 of expenditures that are made by the Office of the Friend of the Court in connection with the activities, the eligible activities that that program funds. So for every dollar that is spent on child support, establishment, collection, enforcement, 66 cents then comes back from the federal government to fund those activities. That is the largest source of revenue to the Friend of the Court, fund. And in 2012 and in 2013, we are receiving roughly $1,040,000 back to the Friend of the Court fund through the cooperative reimbursement program. Friend of the Court also receives as additional revenue item incentive money. This is also federal money. It is paid to the states and then distributed to the Friends of the Court. It's based upon performance factors, so the better job that we do establishing support orders and collecting support, the more incentive money we receive. It's a very large pot nationwide, but that's 50 states and then all the individual agencies that share in that revenue. That source of revenue for us has been running about $170,000 a year. We also have been receiving a state grant. This was supplemental due to changes that had occurred a couple years ago in the cooperative reimbursement program funding. The state wanted to make sure that the Friend of the Court funds didn't receive any less money than it had received before, so they have been contributing to the Friend of the Court fund for the last couple of years, and that has been about $117,000 a year. Friend of the Court is also the court is allowed to assess court costs in connection with child support enforcement. From that, we receive about $24,000 a year. There's a statutory fee of $3.50 a month that is assessed on all child support cases. That generates about $90,000 in revenue to the Friend of the Court fund every year. And then also there are motion and order fees that are charged on child support, parenting time, and custody motions that are filed. That's generating about $29,000 to $30,000 worth of revenue every year for the Friend of the Court fund. Despite all those different revenue items, Friend of the Court still has a little funding gap, if you will, between the expenditures that I mentioned earlier and all these other revenue sources. Currently, that gap is met by the 3 counties that the Friend of the Court serves, so Grand Traverse, Antrim, and Leelanau. The contributions to the Friend of the Court fund by the 3 counties are based upon their percentage of the caseload that exists in the office. In 2012, which is, again, the last year that I think all the numbers are final for, Grand Traverse County's contribution to the Friend of the Court Fund was $350,000. However, that's a gross number, and I believe one of the graphs or charts that was provided in your material, I wanted to show you the contribution and then the net contribution. Because the counties also bill the Friend of the Court Fund for indirect costs. All the counties have an indirect cost plan, and it is a mechanism to allocate general fund items to bill back to the Friend of the Court Fund. So in that same year, 2012, the last year that we had all the, we have final numbers for, the indirect costs that were billed to the Friend of the Court Fund was $198,000 from Grand Traverse County. So the net contribution to the Friend of the Court Fund for Grand Traverse County for 2012 was $156,000, and that's out of our $1,958,000 budget for that year. So Friend of the Court does need those contributions from the county in terms of the overall budget of the Friend of the Court. Again, most of our revenue items cover our costs, except for these contributions that we get from the counties. And the county's contributions have been going down, not a lot, but a little bit over the last couple of years. Any questions about the Friend of the Court Fund budgeting?
As far as out there in the, every year, either the state or the feds have a new way of changing the formula or changing their incentives or changing something. Anything going to be changed soon?
Not that I'm aware of. And as I said, this has actually been a nice couple of years. Things have been pretty stable for the last few years, which is why we see the level of funding and the contributions of the counties to the Friend of the Court Fund has been pretty stable over the last few years. There's been some changes, the one I mentioned about the CRP funding change and how the money was accounted for, which then the state stepped forward and allocated this backfill money, is what it's called, in the state grant that is now entered into our revenue over the last couple of years, has made up that change that occurred 3 years ago, I think. So far, no, Mr. Bennett, I'm not aware of anything on the immediate horizon that's going to change that, but
No change
yes,
in
these
incentive,
things
no?
happen.
Incentives probably going to stay the same?
Incentives have been going down. I think Friend of the Court was at one point getting about $200,000 in incentive money, and we're roughly getting about $170,000 now. And that is mostly a function of more people are sharing in that federal incentive money pot. But yeah, I think it's probably been over the last 5-6 years or so, it's gone from 200 to 170. So although some decline, not a terribly significant one.
Yeah. And how many staff members do you have?
23.
23 staff members. And as you said, it's about $350,000 a year is the county's net.
That's
But
your
then
gross. Your net was
subtract out
about,
indirect cost,
yes.
it's, $150,000,
Right,
156.
exactly,
I think you
yes.
said. So I think that was just about all we had on our list.
Well, Don and I have had this conversation a lot, the only comment that I have to make to the Friend of the Court, I certainly appreciate the fact that, deadbeat dads need to pay their bills and all of those kind of things. If there's anything I'm critical of and not necessarily our department, just the critical of the process, is they, at least from my experience, they don't do a very good job of reevaluating these guys' income and adjusting the amounts that are taken out of their checks every week. I have a number of employees, and over the years I've had a number of employees that are paying money. I've got a man right now that's and he has some arrearage charges, and my court order takes well in excess of 86% of his paycheck if I were to actually take everything that the court order says. Legally, they can only take 55%, but to send 55% of his paycheck to the state of Florida to his ex-wife and wherever she's living, I don't know. And how can this guy possibly move forward and create a life of his own? And it's, I don't know what the right answer is, But, you know, it's just, there's no conceivable way, you know, at this point, I send them 50% of his paycheck every Friday morning. And it's amazing to me how this guy can possibly survive, you know, and I've been, you know, in this particular case, I've been paying it for 3.5 years. But I just received a new court order shortly after the first year from him, which if I paid the amount of money that the court order says, I would be sending them 86% of his paycheck. And I don't know how they expect anybody to survive like that. You know,
I know the case because you called me about it.
And I've sent you the paperwork, and we've sent all the paperwork to the state of Florida.
Good.
But you know, unfortunately, there's just got to be a better way that we can evaluate these. You know, we can have this guy, you know, maybe his ex-wife is remarried to some billionaire, and he's still sending 50% of his paycheck to her every week. You know,
yes, it is unfortunately not one of our cases.
Right,
and,
this one isn't. But I have had them that you and I have talked about that are here too. It's just, the only thing that I can stress is we need to figure out a way to evaluate both the income of the man, if that's the case, that's paying the child support, and a way to evaluate the financial abilities of the lady who's receiving those financial payments.
Yeah, and it's hard for me to comment on what goes on in the state of Florida because I don't
understand
work there. But, you know, in Grand Traverse County and in the state of Michigan, you know, we have mandatory child support guidelines that we use, and they are based on the incomes of both the custodial and the non-custodial parent. Our office, I think we did between 700 and 800 reviews of support orders last year. That's a lot of reviews. And quite frankly, I mean, Judge Power and Judge Rogers have always been very clear to me that that is a big priority for the office, that if we are approached by, I mean, either a custodial or a non-custodial parent that can demonstrate a significant change in their income or their situation, we are to review those court orders. And so, I mean, locally, I can assure you that we do a really good job at that.
Right.
I know it's unfortunate when you run into a case that, you know, we have very little control over. Hopefully, with the one that you mentioned, we were at least able to direct him to who he needs to get in touch with, you know.
And, you know, we, obviously, you and I have had the conversation. I guess my point is just that this isn't the only case. There's a lot of cases out there, and I've had them in, you know, local cases in the past and cases from in the state of Michigan where you know that this guy's sending a significant amount of his paycheck, and to be honest with you, his ex-wife didn't need it. He needed it more than she did.
Other questions? Yeah, how does the Affordable Health Care Act affected friend of the court collections and how they are going to be taking care of that in the future?
Oh, that's like a huge issue, isn't it? It's not going to affect our collections. I think it's probably going to affect a few things that affect us tangentially. For example, it's my understanding of the Affordable Care Act that it is the parent who claims the child as a dependent on their income tax return who will, one, have to demonstrate to the federal government that there is coverage, and two, will be the person that's eligible to receive whatever credits are available to obtain that coverage. It's not something in which we're directly involved, but issues like which parent is going to claim the child as an exemption on their tax return is probably going to become a more important issue than it was previously. I understand that Michigan did pass the expanded Medicaid program, so I think we'll see more families that will qualify for Medicaid coverage for their children than did before. At this point, those are kind of the things I'm anticipating, and I think they're more tangential issues to us than direct.
Okay. It's just going to be more challenging, I think.
More things for them to ask us to get involved in.
Right.
Yes, I think that might be true.
Well, we get orders all the time that says that the gentleman has to have health insurance available on the child, you know. And unfortunately, I've got a number of them that have signed off and chose to not have health insurance, and you know damn well it's because their girlfriend and their children are on Medicaid. Even though the health care insurance is available to them, they will opt out and take, $2 an hour more money in wages rather than have the health insurance that's available to them from their employer. And the kids are being paid for by Medicaid.
Yep. One of
The way it is.
favorite people that I hired was dragged out of prison because they put him in prison for 3 years for non-supportive child support, and he had a full-time job. So he took him out of a full-time job, put him in prison for 3 years. I hired him and started to take the child support out of his paycheck, and he stayed with me for over 12 years, and we got it paid off. But that direct, taking it out of the paycheck makes all the difference in the world to be able to make sure that these things are being paid. But I think, also the economic impact in the community is huge. Not only, that the kids have some sort of money, supposedly, hopefully, that it impacts the kids, so they're not living in poverty, but they really are. When you're supporting two different households, you're both going to be in poverty. There's no getting around it.
One of the first things we say to parents that are splitting up is what covered one unit before now has to cover two. There's just, the math never works out quite well,
It doesn't work. Yep. Thank you.
Very welcome.
Appreciate it.
Thanks, Sean.
And you have a thankless job.
And
Yeah, well, I do say thank you for the work that you guys are doing. It's phenomenal what your staff is doing.
I say thanks even when I call her at home.
Yeah, well. Yeah, so.
I might add, we are very fortunate to have Dawn as friend of the court. When I was practicing law here, she was an experienced commercial litigator, and then she came over to work as a friend of the court case manager. And, we thought that was great, and then when Steve Woodrow left, we have this extremely capable person who knows the front of the court from the ground level of being a case manager, and we've really lucked out, and thank you, Dawn, for she's committed to another 5 years, too, serving as friend of the court.
Good. Well, we are fortunate with the staff that we have in all of our courts. In fact, it's throughout the whole county, because we have people that really care and really do their job. And to me, it's just amazing to me the quality of the staff that we have.
This is the judge, this is Judge Powers.
I thought we could talk about the circuit court budget itself. I was called by the administrator's office, did I have any PowerPoint presentations? And I'm still struggling with the opaque projectors, so you're going to have to look at pieces of paper, and we'll go with that. I think you did get, hopefully, from us a memo just a few days ago that answers the specific questions, or I think were put to every county-funded entity, and also another electronic copy of our annual report for 2012, which answers a lot of the specific questions. But I thought I could add a few things to that. Our budget, as approved for 2014, is $1,854,000. And our budget, our 2013 expenditures, what actually was spent, now that's as of January 31st, but for 2013 was $1,852,000. So we spent $1,852,000 last year, and we're supposed to spend $1,854,000. That's $2,000 more this coming year, which of course is a fraction of 1/10 of 1% increase or something. So in fairness, it's not all that comparable, because the retirement payment, which is largely on back obligations that the county has for over the years, has been reduced for us by about $70,000. So it's not exactly an apples-to-apples comparison. And on the other hand, in that budget last year relative to 2013, I told you what we spent. That was $42,000 less than was budgeted. And in previous years, we've actually given back usually more than $42,000 back to the county, because we don't tend to spend what what is budgeted. So there isn't a big increase, and we don't, we generally give some back, so I think it'll be probably won't cost the county that much this coming year as it hasn't in the past. One thing I thought would be worth talking about, because we did discuss and you did step up and help fund some of the e-file expense, the one-time only upfront e-file and document management system expense to get the programming done so we could get that installed. And I think it might be worth talking briefly about some of the savings, if I can find that piece of paper here, that have occurred as a result of that. An easy, tangible one that can't be disputed is copy machine, postage, and office supply costs. Now, in 2009, we spent $27,000 some in those three, copy machine, postage, and office supply. In 2013, we spent $9,256. That's $18,000 less. So $27,000 to $9,200. So there has been and that's per year. Now you've got an $18,000 per year savings that goes on indefinitely. In addition, there have been some personnel savings out of this. In Leelanau County, they reduced one person, and the Leelanau clerk contributes about half of that to the time savings of e-filing. Our clerk's office did not replace a person, and I think a lot of that is e-filing. So there have been significant personnel savings as a result of the e-filing being so much quicker and easier and less work to be done every time a file has to be opened, and every time a piece of paper is filed, they used to have to go find the file, pull it down, stamp, punch holes in it, but then they'd have to enter it in the computer and so forth. Well, now it comes in a queue. They enter it in the computer and hit a button, and it goes to the electronic file. So it has saved considerable. I think we'll save a lot more over the years. So just to let you know that I think it did pay off for the three counties. Now, let's see here. Jail capacity. You may recognize one of these pieces of paper. You may have seen this before because I handed it out before, but repetition is an excellent tool. And again, we have a jail capacity that has now been reduced to 167 beds. And in 1990, when Judge Rogers started, in 1992, when I started, we had 171 beds. And obviously, and there's a breakdown in this one page of the history of jail bed capacity and how we got to where we're at. But 167 or 168 beds, 23 years later, does not reflect a population increase that has been very substantial and is also set forth in this piece of paper, does not reflect increased law enforcement personnel. You just earlier in 2013 added another prosecutor. It doesn't account. I mean, you can't have more people, more sheriff, and more police and more prosecutors, and then expect that you're going to have fewer jail beds used. It just isn't going to work. Now as I understand it, the county has stepped up and paid to rent beds in Leelanau and maybe other places, and I think that may be a good short-term cost-effective way to go about it. I guess I'll leave it to you, but it's a problem that is, we get through and incarcerate all the people. At some point, if we actually stuck with 168 beds, we're going to be releasing people early, and that has some very damaging effects on some of these alternate programs that we have put in. We, meaning not just us, but you, law enforcement, and the state have all been involved in community corrections and other alternate programs that disappear. Because if I'm in jail and I know that I'm the kind of crime that we're going to let me out early, and I have a choice between signing up to a situation where I have to talk to some irritating social worker, tell me about my social problems, which are many, or I can just wait another 2 weeks, you're going to let me out and I can go back to drinking. Guess what I'm going to do? So it destroys these programs if we do that. So in any event, just a reminder. A second thing I'd like to look at, I handed out, is something that I'm not sure you've seen this, but we did it, have shown at least some people. This is indigent defense costs. As you, I'm sure, are aware, each county has to provide lawyers to poor defendants who can't pay for their own. The overwhelming majority of criminal cases in the circuit court do have appointed indigent defense counsel that are paid for by the county in question, Grand Traverse in this case. And we collect a lot of that money back. And our collections effort in 1990, over here under the collections column, it's got nothing there, because in 1990 the total collection effort was $10,000 in this circuit. And there was none in essence. And now the attorney fee collections are set forth there, and you can see how much attorney fees have been collected, and you take what's spent, the collections, and you've got a net. We have the number of new felony cases, and we put down here the average per case. Now, it looks kind of funny because it goes up and down. That's because there may be a lot more collections in one year that have to do with past years' indigent defense costs, and they get accounted for in the year that they're collected. So it's not year by year is difficult to compare. But my point is, you're paying a lot less per case than you did in 1990. And in addition, our system is event-based. So attorneys get paid based upon what happens in the case. So an attorney goes to trial, gets paid more than an attorney that pleads a person guilty of the first event in district court. And so the old system was a flat fee, X $100 per case. And so if you went to a 3-day trial, the attorney ate it, basically. And that obviously provides an incentive to force a client to plead guilty when maybe they shouldn't, and we don't want to have that kind of incentive. We want justice, we want fair, obviously we want efficiency, we want justice too. So that's just an update on indigent defense.
Isn't the state going to take that over? Would you
that is coming up, and I was somewhat involved in that. I was kind of the skunk in the room. I went down and testified, and it was, I had a great time. But in any event, what has happened is it's become kind of a cause that indigent defense is terrible. These poor criminals aren't getting good defenses, and they introduced bills to have the state take over, and they're going to set up, and the bills passed, and I could talk about why they're bad bills. It's not important at this point. The bills passed. They require the governor, I think in the Supreme Court and a couple other people, to appoint members to this commission that will set up standards for indigent defense, which must be approved by the Supreme Court, and then each court and county will have to submit an indigent defense plan that complies with these guidelines that are adopted by this commission. It further says that each county will have to fund up to what they funded in the year ending, I can't remember the exact date, but it was a date last year. So it's already gone by. We know how much you're going to have to pay. Plus, I think there's an escalator, a CPI or some such thing. So that's how much counties are going to have to pay. It's unfair because we've done a good job, and they don't give us any credit for the collection. So it's the gross cost.
Yeah.
So we've done a good job and been fair to our indigent defendants. There are a couple other counties that have done a terrible job, treat their defendants and really there is a legitimate beef about the quality of the defenses given to those people, and they get rewarded by having a low base in which to pay. And the state will then pay all the cost on top of that. That's what they say. Now, anybody here from the state? Good, because we don't want to tell them, but I'm sure they'll figure it out. Here's how they're going to get around that. And you who all lived through the state budget crisis the last couple of years, I think we can figure this out very quickly, is they just take reductions like they did with revenue sharing, and that's one way. The other way is by law require that when we collect money for indigent defense attorney fees, if they require that the first money collected reimburses the state for their portion before any of it gets reimbursed to the county for the county's portion, they will in effect pay nothing. That's an easy way to do it, and that's it's so it's going to you're in the process of being screwed basically. But however, nothing. The good news is they have not appointed this commission. It's dead in the water, and it was a real head of steam. I mean, even the Detroit News was editorializing about how terrible the system was, and we got to fund it more. And I'm saying, when they're, sometimes I wonder about them. But in any event, this commission has not been established, even though the law was passed last year, in the middle of last year, and the word is, and I don't know that this is correct, but the word is that they've now focused on the fact that this is $150 million item out of the state budget that wasn't there before, and that people are beginning to say, well, you know, maybe we ought to just not do this, or maybe we ought to forget it for a while. So maybe nothing will happen, but you're right, that's something that's on the horizon. Now, that's one of the three things I want to talk about for the future that we need to talk about in our budget. Indigent defense lawyers have not had an increase, not inflation, nothing. No increase whatsoever since 2007 or 2008. And obviously nobody who works for county government has had no increase at all in that period, well, except possibly county commissioners and judges.
Exactly.
All right, we're the two that are done. But the point is, something needs to be done for them. There are some changes we want to make in the reimbursement system that would probably save us some money, the details of which we can talk about at some point. But that's something, some modest increment addition to take care of some inflation over those years is probably appropriate. Second thing, our referees, domestic relation referees, have an extremely difficult job and an extremely important job. They hear the disputes about parenting time, about custody in the first instance. They hear people who are objecting to the issuance of personal protection orders, and sometimes people think, well, it doesn't affect me, but anybody can have someone claim that you're pestering them, and a personal protection order gets issued. That's that could be a black mark on your reputation. You want to have a fair hearing to make sure that that's right, and to get it dissolved if it wasn't issued. If it wasn't issued for a good reason. The referees handle that. These are extremely important jobs. They also do a lot of work on the collections end of show-causing people, aren't paying their support, and dealing with the individual problems that people have, such as what Sonny was outlining. They're extremely important jobs. We had originally all agreed, kind of informally, that they were going to get paid what middle-level prosecutors pay. Not what the top level, not the prosecutor and the chief assistant, but middle level. Not what the entry-level prosecutor, but somebody in the middle-level ranges. And that has kind of fallen by the wayside over the years, and they need to be bumped up to the middle-level prosecutor range in the interest of fairness and recognizing the importance and difficulty of their job. Lastly, we have one piece of e-filing document management needs to be done. That's the Department of Corrections Probation Office. They're as you probably are aware, are a branch and an office of the State Department of Corrections. They don't work for us. The salary and expense, personnel expense is paid by the state. We do provide an office, and I don't know if do they rent the office from us or not? So I guess we provide them with an office.
Supplies,
And also office supplies and a few miscellaneous things. But they are our probation office, much like the probate court probation office, except they work for the probate court, and the district court probation office works for the district court. Well, not with circuit court. But we deal with them all the time. Paperwork flowing back and forth, probation orders, bench warrants, all sorts of things back and forth. And we would like to take the last piece of this, which is to get that involved in the document management system. We've been quoted $38,000, and we're working on something more realistic, a little bit less than that with ImageSoft. We've been good to them, and they've been good to us, but Judge Rogers especially has helped them out a lot in demonstrating this system to other potential customers for them. We'll try to get a better deal, but at some point we may talk about how we'd like to do that last piece. That's basically what summary of what I want to talk about, and if you have any questions, of course, I'd be happy to try and answer them.
Okay. Larry? Judge, kind of a status report of all the scanning of documents, projects that we had going on. And
of what?
Scanning of documents, current documents, and then maybe some of the older files are hanging around.
Now, Friend of the Court is now completely scanned and has been for several years, and everything is done digitally. Dawn, say yep. And
all right. And all the circuit court records have
now all the current files, starting some as early as the beginning of some in 2012, but some of them this past year. All those that are started new are all done by the initial paper document, the complaint that starts the case under the Supreme Court order that authorizes to do this. There has to be a paper document filed.
Right.
And what our clerk's office does is images that in to the electronic file. And then everything else has to be e-filed electronically. So it's handled that way. Now, there are still a few files where things come up that are from a 2008 file. I just had one from 2008. So the paper file is necessary for that because I need to look at the judgment of divorce in that case to settle the dispute between the parties. But over time, all the files will, the old ones get older and older and less use for them.
Right.
You can image these. And I believe that the Supreme Court's now authorized that. And it may be that as a document storage method, rather than microfilm, because you have to ship it out to do microfilming and all that, it may be that an imaging system would be a better way to go, but you probably have to take that up with Bonnie and her people,
I think
who
Bonnie
I'm
just
sure have
sent a
looked into
thing
it
out
more
that
than I
said
have.
The courts just approved that.
Supreme Court.
That you
Yeah,
can
just
go ahead.
recently.
Yeah.
I think recently the Supreme Court approved allowing them to be stored in
Yeah,
that.
and, but at this point, 98% of the civil stuff is all imaged. I can call it up on my computer. The criminal, anything that's current is now pretty much imaged. There might be old things, you get a motion from somebody in prison and from a conviction 5 years ago, we're always going to have those. But in terms of day-to-day current cases, they're almost all imaged now. And
That's great. Good job.
Other questions?
And I think that's helped the clerk in space too, because I think they still got those old files, but they don't have to find new space for new files. And if they clean out the old ones, that'll be less and less.
Bonnie
needed.
almost had a heart attack when she found out that we had water, and she was concerned about whether or not it was going to affect any of her records. So we got to get them imaged and get them out of there. So, Sonny?
Great. Well, I guess the first comment I want to make is our community has been very fortunate to have Tom Power be the skunk in the room a lot of times over the last few years.
Well, that's very kind. Thank you.
I certainly appreciate his efforts. As far as your jail population, you're kind of preaching to the choir here. You and I sat on the same Blue Ribbon Jail Committee almost 10 years ago that identified we needed 300 beds. We still haven't figured out a way to pay for it yet.
Juvenile.
Most important piece is we always have to make sure that we have that one empty bed when Judge Power needs it.
that's true.
That's the most important. So.
Having gotten into that, we should designate where that's going to be. The sooner the better. Because all the time that you spend on this is the longest part of the process is where is this going to go?
And I know we have all the budget constraints and all of the things that issue into it, and we always get hung up on what it's going to cost for the jail. We are at the point, we need to identify, we don't have to identify the need. We simply have to start moving forward toward the placement and the funding and the construction of that jail.
Budget-wise, we're 10 years away from being able to do it.
Well, we can't wait 10 years.
I'm just...
Well, if you can outsource for a while.
Yeah.
I think you're as far away from it as the day you get it cited. The day you get it cited is the day you can start counting on the clock.
Well, I've heard
when
there's
you
a
can get it done.
building down Wellington Street, just south of 8th Street might be available.
Come on.
Just kidding.
Co-ed cells would take.
But no, if you were to announce that this is the site, here's the plan, we're going to put it on this piece of property, and it's going to be about this big, it's going to have this many beds. Once you make a decision to do that and get a public hearing on it.
5 years.
Get, maybe even a citizens committee to go all over the county and look and see where good places might be and then make some suggestions
I'm
to you.
happy to make that motion.
Once you make the decision on where it's going and you get that firmly rooted in the public's mind, then you can, then it's just a matter of putting the money together.
I thought we were going to put it on Lafreniere, on our property up there.
That's what I thought.
I made that motion one night, and I was asked to withdraw the motion, so.
Yeah, well, so continue to work.
Somebody told me I needed to cool my
Judge,
heels.
thank you very much.
Okay,
We
thank
appreciate
you.
it. By the
I
way,
appreciate
that's
it.
not the only time you were a skunk in the order. I've heard you've gotten there more often than not. We appreciate your
And I appreciate
perseverance.
Thank you.
Thank you. At this point, we have second public hearing.
Public what?
Yeah. See no other public hearing?
He did.
Thank you very much for all your, the staff and your time that you've been able to put into this. It's been very enlightening, I think, for not only for your organization, but all of our different departments. It's been very important.
Motion to adjourn, Mr. Chairman.
And we have it. Thank you.
Go back to work.
Class for.
I hope not.
Greens.